In the previous section, we examined the agent inspection process, including how agents should walk the property, document observations, and recommend further professional investigation when concerns arise. Those procedures are an important part of risk management and professional practice. However, disclosure responsibilities extend beyond the physical condition of the property itself. Real estate professionals must also understand legal disclosures, statutory requirements, and special assessments that may affect the buyer's financial obligations. One example frequently discussed through real estate legal hotlines involves community facilities districts, CFDs, and how buyers can research whether a property is located within one of these districts. Community facilities districts, CFDs. In September 1988, the Arizona Community Facilities District Act was passed into law. This legislation allows a municipality or county to form a community facilities district, CFD, for the purpose of financing and constructing public infrastructure within a specific development area. A CFD can be used to fund improvements such as roads and transportation infrastructure, water and sewer systems, parks and recreational facilities, public safety facilities, street lighting and landscaping. Although the law has existed for decades, the use of CFDs has expanded significantly as Arizona communities have continued to grow and develop. A CFD allows the government to finance infrastructure by issuing bonds that are repaid through special assessments or taxes placed on properties located within the district. As a result, buyers purchasing property within a CFD may be responsible for additional property tax obligations beyond standard property taxes. For this reason, determining whether a property is located within a CFD is an important step during the buyer's due diligence period. MLS disclosure of CFD information. Due to the growing number of community facilities districts throughout Arizona, the Arizona Regional Multiple Listing Service, ARMLS, added a field to the residential profile sheet in September 2013, indicating whether a property is located within the boundaries of a CFD. Listing agents participating in RMLS should make reasonable efforts to determine whether the property is located within a CFD and populate the appropriate yes or no field in the listing input form. While this MLS field can provide useful information, buyers should never rely solely on MLS information when making decisions about property taxes or special assessments. Buyers should independently verify the presence of a CFD during their inspection period, since a CFD can significantly impact the buyer's long-term financial obligations. How buyers can research the presence of a CFD. There are several ways to determine whether a property is located within a community facilities district. One of the most reliable methods is to contact the county assessor or county treasurer's office. For example, buyers purchasing property in Maricopa County can research CFD information through the Maricopa County Treasurer's Office website. The process generally includes the following steps: locate the property's parcel number, visit the Maricopa County Treasurer's website, enter the parcel number into the search field, access the tax summary page for the property, select View Tax Details, scroll to the section labeled Special Tax Districts. Within this section, the buyer can determine whether the property falls within the boundaries of a community facilities district or other special taxing district. Once the buyer has obtained this information, they are in a much better position to make an informed decision regarding the purchase of the property. Limited legal exemptions and exceptions. Arizona real estate transactions are governed by numerous federal and state disclosure laws, many of which include specific exemptions and exceptions. Real estate brokers frequently receive questions from out-of-state sellers, lenders, relocation companies, and institutional owners regarding whether they are subject to the same disclosure requirements as traditional sellers. In most cases, the answer is yes. Most disclosure laws apply regardless of whether the seller resides out of state or whether the seller is an institutional entity such as a bank or relocation company. However, certain laws do contain limited exemptions, particularly with respect to lead-based paint disclosures, affidavits of disclosure, and wastewater facility inspections. Lead-based paint disclosure requirements. Federal law requires sellers of residential property built prior to 1978 to disclose the presence of known lead-based paint hazards before a buyer becomes obligated under a purchase contract. This requirement is established under 42 U.S.C. paragraph 4852D, along with associated federal regulations. The law requires sellers to provide buyers with a lead-based paint disclosure form, provide the EPA lead hazard information pamphlet, Disclose any known lead hazards. Provide buyers with the opportunity to conduct a lead inspection. However, certain property types are exempt from these disclosure requirements. Examples of exemptions include foreclosure transactions, rental housing certified as lead-free by a qualified inspector, leases of 100 days or less with no extension, lease renewals where disclosure was previously provided, mortgage servicing transactions, zero-bedroom dwellings such as studio units, housing designated exclusively for elderly residents or persons with disabilities, unless children under 6 will reside in the property. These exemptions are outlined in federal regulations, including 24 CFR Paragraph 35.86, Affidavit of Disclosure Requirements under ARS, Paragraph 33.422, a seller transferring 5 or fewer parcels of land located in an unincorporated area of a county must provide the buyer with a written affidavit of disclosure. This document must be delivered to the buyer at least 7 days before the property transfer. The affidavit typically discloses important information about the property, including legal access, utility availability, floodplain status, zoning information, water availability. There are only limited exemptions to this requirement. The affidavit is not required when the property is being sold by a trustee conducting a trustee's sale under a deed of trust, an officer conducting a judicial execution sale to enforce a judgment or foreclosure, on-site wastewater treatment facility inspections. Arizona also requires inspection of certain on-site wastewater treatment systems, commonly referred to as septic systems, prior to property transfer. Under AAC R18-9A316, any on-site wastewater treatment facility installed after January 1, 2001 must be inspected within 6 months prior to property transfer. After the transfer occurs, the buyer must submit a notice of transfer to the appropriate county agency within 15 days. The only exemption occurs when the wastewater system was never placed into service prior to the transfer. These requirements exist to ensure that septic systems are functioning properly and do not create environmental or public health risks. New disclosure requirements. Wholesaler status. Arizona law has also introduced new disclosure requirements for real estate wholesalers. Wholesalers are individuals who enter into a purchase contract for property and then assign that contract to another buyer for a profit. Under recent regulatory updates, individuals engaging in wholesaling activities must clearly disclose their status in the transaction so that all parties understand the nature of the arrangement. This disclosure requirement helps protect consumers by ensuring transparency regarding who actually owns the property and who is profiting from the transaction. Conclusion. Disclosure laws in Arizona exist to protect both buyers and sellers by promoting transparency in real estate transactions. While certain laws contain limited exemptions, these exemptions are not based on whether the seller resides out of state or whether the seller is an institutional entity. Violations of disclosure laws can result in serious consequences, including rescission rights for buyers, civil liability, financial penalties, and in some cases, criminal sanctions. For this reason, the safest approach for real estate professionals is simple. When in doubt, comply with disclosure requirements and provide full transparency to all parties involved in the transaction. Online discussion. Why should buyers independently research whether a property is located within a Community Facilities District, CFD? Answer: because CFDs may impose additional property tax obligations or assessments that could affect the buyer's long-term financial responsibilities. Why do disclosure laws apply to institutional sellers and out-of-state sellers? Answer: Arizona disclosure laws apply to most property transfers regardless of the seller's location or ownership structure. Why is it important for real estate agents to understand legal exemptions to disclosure laws? Answer: understanding exemptions allows agents to properly advise clients and avoid compliance violations during real estate transactions.